in the view of the petitioner, His Lordship Justice Ackaah-Boafo should not be considered for nomination and appointment to the Supreme Court. The committee, after due consideration and careful reading of the petition as well as the judgment, came into a conclusion that the allegation contained in the petition that the judge has insulted and attacked the petitioner is completely unfounded. Furthermore, by a judgment dated 22nd June 2023 and entitled Adolfsevia Ghana Limited, represented by Anthony Raoul, the petitioner herein, versus Drivers and Vehicle Licensing Authority, the petitioner had appealed against the said judgment of the High Court, presided over by Justice Ackaah-Boafo, to the Court of Appeal. And the Court of Appeal, in suit number H1/10/2023, dated 22nd June 2023, delivered judgment on the issues, having considered the totality of the evidence and the judgment. The appointment committee cannot therefore be constituted into the Supreme Court and Judicial Council to review the judgment of the Court of Appeal and take disciplinary action respectively. We are of the view that all issues raised in the petition has been appropriately dealt with by the court. Honourable members, the petitioner furnished the committee through the clerk additional documents. The committee duly considered the additional document and realized that it was a petition by the same petitioner alleging corruption against one Charles Aidan, Deputy Director of Finance of the Judicial Service, addressed to the Chief Justice on 26 April 2021. The Chief Justice investigated the matter and found no wrongdoing against Charles Aidan, the Deputy Director of Finance, and accordingly communicated his findings to the petitioner therein, who is also the petitioner herein. The additional documents have no nexus to the petition he wrote to the appointment committee and have nothing to do with the nominee before us. We therefore see no reason why a petition and findings involving Charles Aidan, the Deputy Director of Finance, could be admitted and used as evidence against the nominee, His Lordship Justice Ackaah-Boafo, since the documents have nothing to do with him. Honourable members, Article 1273 of the 1992 Constitution of the Republic of Ghana says that a justice of the Superior Court or any other person exercising judicial power shall not be liable to any action or suit for any act or omission by him in the exercise of the judicial power. The complaint against the nominee is about the exercise of judicial power in conducting the matter leading to the judgment under reference. The committee this morning ruled that the petition is frivolous, vexatious, worthless, unmeritorious, and it is baseless in law and the facts. A complete abuse of the process. During the committee's meeting, our attention was drawn to publication by some media houses yesterday. Before the committee's meeting today, allegation that Parliament had thrown out the petition against Supreme Court Justice nominee, Justice Ackaah-Boafo, and that he was scheduled to be vetted today. We shall appropriately consider the conduct of the media houses if the need be, We are therefore proceeding to vet the nominee under reference. Thank you for your rapt attention. Honourable members, we shall appropriately consider the conduct of the media house if there need be, and we are therefore proceeding to do the vetting. I will then give the floor to the minority leader if he has a brief remark on the issue at stake.
Chairman, thank you for the opportunity. Chairman, I am in agreement with the views you've expressed for and on behalf of this committee. Indeed, as a country, we need to veer off from trivialities and situations where we subject people's reputation to undue public ridicule. I am happy that this committee has boldly stood up for democracy, rule of law, and in helping deal with matters as frivolous as what came before us. Unfortunately, if you look at the ongoing trial of the Chief Justice of the Republic, we have one Daniel Ofori who refers to a judgment which the Chief Justice was involved as a basis for attacking the woman and calling for her removal. If you also read Yakubu Akogo Ayamga, similar frivolous allegations are made that the Chief Justice made certain pronouncement against him in open court. Unfortunately, these two scenarios have been deemed to constitute a prima facie case amounting to misconduct, justifying inquiry into the conduct of a Chief Justice. And the Chief Justice of the Republic is on suspension as a result of this. I am happy that as a committee, we stood firm to the test and we have risen above pettiness and trivialities. Chairman, my second comment has to do with feedback from certain quarters regarding the minorities' stance on some of the issues that have come up as part of this vetting. I would want to pray the public to appreciate where we're coming from. We are not here to get personal. We are here to deal with the law and issues of public policy, good governance. So for those who are saying that, oh, you guys are lawyers, why are you subjecting nominees to all these hard questions when you appear before them? They are also likely to do that to you. Well, my answer to them as a person, I speak for myself. If Mr. Speaker grants me that exemption to practice, I will do as I've always done. If a judge believes that he should rule against me because I did my work, so be it. I've never been afraid to practice at the Supreme Court. When I was in opposition, 2013 to 2016, I was a regular visitor in that court. And I was never deterred by any action or any ruling against me. I will do my job, and I will do so out of great deference, out of great respect. And I'm not here to attack anybody's person. So I want those who are being impatient and intolerant to please understand the space I am in. That is the work of the minority. Our job is to enrich democracy, and that's exactly what we are doing. Don't get irritated. Please bear with us. Thank you very much.
Honorable members, before proceeding to administer the oath, let me place on record that the issues raised by the minority leader regarding the petition against the Chief Justice are before another body and will be dealt with in accordance with law. There was also no evidence or issue of a judge dealing with the minority leader in any manner whatsoever. We are dealing with issues of facts and applying the law to the facts. So I plead with the minority leader not to preempt anything. I will therefore go ahead and call on the clerk of the committee to administer the oath.
I do hereby administer the oath.
I, Ackaah-Boafo,
Do in the name of the Almighty God swear
do in the name of the Almighty God swear
that the evidence I shall give before this committee
that the evidence I shall give before this committee
touching the matter in issue shall be the truth,
the truth,
the whole truth,
and
nothing but the truth.
nothing but the truth.
So help me God.
So help me God.
Honorable members, may I proceed by asking the nominee to give us a brief background.
Thank you very much. Good morning, Chair. Good morning, members of the committee. I'm Ackaah-Boafo. My mother, the late Agnes Kwesen, is from Wasa East, Mamponso, raised in Aboso, settled at Insusaiden in the Western region. My father, Nicholas Iduaka, is from Western North, Amefie and Ackaah-Krom. So from the records, I think I'm the first nominee to come from the Western North. And for the Western region, I'm actually the third nominee from the Western region. I had my secondary education. I started from St. Augustine Secondary School at Bogoso in the Western region. I left there after 2.5 years, came to Winneba Secondary School, Winnisekwe. I had my O-levels. I had my A-levels at Secondary College. From there, I did my national service at Aboso in the Western region. Came to University of Ghana, Legon. I was a resident of the Commonwealth Hall. I went through with an LLB degree. From there, I went to Ghana School of Law. I was called to the bar in 1996. I did a brief practice. I did my pupillage at Bosonchi Salmon Associates in Takoradi. From there, I joined my brother, Ben Ackaah-Jesse, to start Kendrick's law firm. In 1999, I left Ghana. I went to Eric Castrain Institute for Human Rights and Public Administration, University of Helsinki. I had my LLM there. I was then enrolled in a licentiate program, which was towards a PhD, but I didn't complete it. So I migrated to Canada, where I enrolled at the University of Ottawa Law School for my pupillage. I was called for my post-Canadian bar. I was called to the Canadian bar as a barrister and solicitor and notary. And I practiced law in Toronto, Canada as a criminal defense counsel. I also appeared before many of the other courts, the federal court, the superior court, did many work there. In 2015, I was appointed as a justice of the High Court, 1st April. I spent 7.5 years at the High Court. In December 2022, I was elevated to the Court of Appeal, where I have continued to work till now. I am married to the beautiful lady behind me, Joycelyn Kuku Ackaah-Boafo. We are blessed with 2 children, Nick and Maud. I'm a born-again Christian, a member of the Full Gospel Church, and grace has found me. I call myself a PGG. I'm a product of God's grace. So I am here today to be vetted for the Apex Court of Ireland. Thank you very much.
Thank you, nominee. Our members will then proceed to take questions. I will start with the subject matter committee members, and I'll call on Honorable Bitsidi to start.
Thank you very much, Honorable Chairman. Congratulations, my Lord. I have a few questions for you. The first is, my Lord, are there enough lawyers in Ghana? And if your answer is no, what do you think can be done to increase the number of lawyers in the country? Thank you.
Thank you very much, Mr. Chair. Well, at the last count, the information I got, because I teach at the law school, is that between 1877 and 1963, there were 570 lawyers in Ghana. And I mentioned 1877 because of the Judicial Act. But from 1962 till now, as of May 2015, as the last call, I think the lawyers from 62 to May 2025 is about 10,400 and something. So in effect, many lawyers or lawyers in Ghana in total would be about 11,000 something. From the Ghana Bar Association portal, as I asked around, you see practicing lawyers will be about 8,000. To that extent, there are not enough lawyers in Ghana, because if you look at our population, then you have about 2,000 people to a lawyer. If I compare it to Ontario, in 2020, the Ontario population is 14-point-something million with over 56,000 lawyers, which will be about 1 to about 7,700. So to that extent, no, there are not many lawyers in Ghana. So I think that something ought to be done. What should be done is something for discussion. And you asked me what should be done. I mean, at this stage, we know there is the Ghana School of Law that train lawyers. There has been conversation that the institutions that train the LLBs should be allowed to do the professional. I will hasten to add that we need to be very careful how we do that. Because if many of the LLB schools producing candidates, the question to be asked is, do they have the requisite material and the qualified lecturers to teach there? Because let me say this. If you produce, let's say, 100 graduates, and they write the entrance exam as it exists now, and you don't have more than 10 people passing, then I think there's something wrong. So yes, we should enlarge it, but we should be very careful, because after LLB, somebody must do pupillage. Do we have qualified chambers to train the lawyers who will qualify? If we have over 8,000 lawyers and there are only about 1,200 registered chambers, there will be a problem. But yes, there's a need to enlarge the number, but it's a conversation that should be had deeply and without any emotions. Thank you.
My Lord, we know your background. As a lecturer, you can be lecturing for the whole day, but we don't intend keeping you for the whole day. So I humbly plead that we observe the brevity principle and short answers will be given to questions.
Thank you, Mr. Chair. Very well noted.
Yes. Any further question?
Thank you, Mr. Chair. I have no follow-up question, but I have a second question for my Lord. My Lord, there is a troubling trend of people using social media to abuse or defame other people. Some hold the view that suing them and awarding damages against them amounts to curtailing freedom of expression.
Do you agree with this position, my Lord?
Thank you, Mr. Chair. Mr. Chair, the Venerable Justice, a well-known justice known to everybody who has studied the law, the name just escaped me, from Britain, and I'm sure by saying Venerable, all of us remember him. In the case of British Steel Corporation versus Granada, said Lord Denning said, freedom, if you want to deserve freedom, the press deserving freedom, they must work for it, because free speech is not taken. In Pakenham and North Carolina, Justice Scalia said, acting on social media, it is like the old style writing in newspapers. Therefore, there must be some guidelines there. So if you go on social media and you use that to abuse somebody, and the person thinks that he's defamed, I think that going into the court will not be gagging anybody. There must be responsibility. People must be responsible on social media. Thank you.
Any further question?
Yes, Mr. Chairman. No follow-up question, but I have a third question. My Lord, my final question to you is that some people argue that the practice of empaneling judges by the Chief Justice allows the Chief Justice to favor certain judges for particular cases. I'm talking about in the Supreme Court. Do you think something should be done about this particular situation? Thank you.
Thank you, Mr. Chair. I think the Chief Justice and paneling judges is an administrative work. But the question you pose also gives me the impression that there's that perception that a Chief Justice can use that negatively or select something. My view is that we should have a statutory legislation about electronic empaneling. Even at the Supreme Court, there should be panel heads with the Chief Justice as one of them. Because my understanding is that at the appellate court, there are senior judges, middle senior judges, and junior judges. So that if you have panels of, let's say, 4 at the Supreme Court, with the most seniors as the heads, and cases are assigned electronically, and it goes to panel 1, which is headed by Judge A, then it cannot be changed. It will help to take away the perception of abuse of a Chief Justice using paneling to do favoritism. That will be my answer. Thank you.
Any follow-up?
Mr. Chairman, there will be no follow-up. And my Lord, congratulations, and I wish you well. That will be all for now.
I'll proceed to give the floor to Ackaah-Boafo Jr.
Thank you very much, Mr. Chairman. Congratulations, my Lord, for the elevation. My Lord, I believe that when the bench is filled with incompetent judges, they will deliver low-cost decisions at the expense of the citizenry that we represent. In your view, how do we monitor and eliminate incompetent judges who see the bench as a benign retirement from the rigorous private practices that we have?
Well, thank you, Mr. Chair. Incompetent judges, I think that to be elevated to any of the benches, individuals go through processes. So once they are appointed, they are presumed to be competent. Now, the judiciary certainly has an assessment section that they assess judgment. I work at the JTI. There are times that a judge may err, that a reference may be made for judges to be retrained at the JTI. And I think that is one means of assessing whether or not people's knowledge in a particular area is not good. But we know the rules for appointment. While the person is qualified and it's a lawyer and is appointed, there's a presumption of competence. And so it is just an issue of building capacity. Thank you very much.
Follow-up, Chair. The conversation for the Ghanaian people is justice delivery. That seems to accord to the benefit of the people we represent. And so it is not just only a matter of the appointing process, but a form of assessment that assures us that judges, whether in their promotional, whatever, is based on competence. So from the Supreme Court that you are going to, what are some of the recommendations in terms of monitoring to establish that competency outweighs any other consideration for appointment?
I honestly believe in an independent judicial commission for elevations and appointments. And that commission, if it's put in place statutorily, will then consider some disappointment. They will assess your work, they assess what you've done, what you are able to do, and that will become the basis. And by the way, in other jurisdictions, you can't even be a judge without voluntary work that you have done for the community to see that you've served them prior and you can serve them on the bench. So I think that that's one way of assessing competence. Thank you.
Honourable members, as we want the nominee to be brief, we should also be brief in setting the foundation for the question. I'll give the floor to Ackaah-Boafo.
Congratulations, my Lord.
Chairman, with respect, not to chip away your powers, but I plead with you to allow things to flow.
My Lord, you stated that the population of Ontario is 14 million and they have 57,000 lawyers. 56,000 lawyers. The size of the Ontario economy is $887 billion. The size of the Ghanaian economy is $8.83 billion. $82 billion. Don't you think that the demand for lawyers in Ontario is driven by the size of their economy as opposed to the population of Ontario?
Thank you, Mr. Chair. I think that is part of the analysis, but the Ghanaian economy figure you just gave also call for judges in this nation. Let's be honest. In my father's Western North, I'm not sure they have more than 5 lawyers there. And it's a regional capital now. You have lawyers work there. So I think that there's a need for that increase in our space as well, because businesses, district assemblies, and private individuals certainly require the services of lawyers. Thank you.
I'm going to ask a follow-up. My Lord, in the 80s, one of the busiest places for legal practice was Western Region, particularly Takoradi and Kumasi, because the economies of these places were booming. And so legend has it that some of the best lawyers, in fact judges of this country, practiced either in Kumasi or Takoradi. And at the time, their population was very small. And so, by way of follow-up, don't you think that the emphasis really and truly is more on economy than the size of the population?
Your contention is right, but you also recognize that for some time now, Ghanaians have become aware of their rights. I mean, look at growing up, there were only few high courts. They were only based at the regional capitals. Now high courts are district capitals and other places. If the courts are there, people understanding their rights will go there. And sitting as a judge, knowing that somebody self-representing is one of the challenges any judge will face. So I think the economy is a consideration, but the population as well, knowing that they have somebody who can advocate for them is also very important. Thank you.
Well, Honourable Inye, you have the floor.
Thank you, Mr. Chairman. Congratulations, my Lord, and welcome to the committee. My Lord, we'll start with judicial integrity. You would agree with me that judicial integrity is very important to sustain the confidence of the public in the judiciary. Can you tell this panel, how have you, as a judge since, I think, 2015, when you were appointed to the bench, maintained your integrity? Thank you.
Thank you, Mr. Chair. I think the judiciary, I will call it the arbiter of the nation. And therefore, the presumption is that when people have been entrusted with power to administer justice, they ought to be ethical. Judges have code of ethics, and that is what is supposed to guide us. How have I done mine? I think that I find this as a fulfilling opportunity to serve this nation. And to serve the nation means that I must strive to be unashamedly ethical. And being ethical means that you guide your integrity in doing your work. Thank you very much.
Now, as a justice of the Court of Appeal, if you should discover misconduct from a fellow judge, how would you approach that?
Well, if it is a misconduct that calls for a report, certainly I think that even as lawyers have obligation to report their colleagues who are caught in misconduct. So the General Legal Counsel, as to whether or not they will do it is another matter. Because anytime I pose this in classroom, the student go, no. So, but if I see a judge in a situation like that, which calls for a complaint, I think I will speak to a senior judge about it. And if it is something that can be resolved without making official complaint, that will be done. If it ought to be officially complained, I will do that. Thank you.
My Lord, in your view, we are going to a different area, AI. In your view, as a justice of the Court of Appeal, do you think the judiciary is prepared or poised to use artificial intelligence as evidence in the determination of cases, considering the fact that these days it's so easy to generate anything?
I will highly recommend the judiciary to be AI literate. The judiciary of Ghana must endeavor to make the judiciary AI literate, because that is the new trend. However, we need to be very careful engaging this, because if we are all literate and as to how it operates, then we are in the front end, and then we'll be able to know the dangers associated with it. Many countries like Canada and UK have guidelines for judges. And so, whilst I recommend that AI literacy should be embraced by the judiciary, then we'll be required to have guidelines to guide judges, so that when lawyers are found in processes with hallucinations, we'll be able to know it and address it. Thank you.
Now, my final question. I believe you are familiar with this statement. It's been in the media for quite some time now. The packing of the Supreme Court by the President of the day, unquote. Do you think that President Mahama is packing the Supreme Court to secure political advantage, or you think that you are being sent to the Supreme Court to deliver justice according to law?
My answer will be the latter part of your question. But on the issue of capping, I will respectfully ask this committee and this House to, before you talk about numbers, look at the jurisdiction of the court. Because the court has over 8 jurisdictions. Last time I checked, with respect, Ghana may be the only country with a Supreme Court which sits every week. In Canada, the Supreme Court sits in sessions, winter, spring, and autumn. So they sit, and they don't deliver more than 65, they deliver between 65 and 80 cases a year. They receive over 500 cases. They do filtering. And at the end of the day, they may accept about 120 and they will do about 65. So before we talk about numbers, let's look at the jurisdiction. And with that, let's try and give some of this jurisdiction to the Court of Appeal to deal with it. And then we can talk about numbers in regards to the Supreme Court. Thank you.
I'm very grateful. Mr. Chairman, I'm grateful. Just that from his CV, it's not a question. From his CV, when you look at hobbies, I see he's indicated that he enjoys singing. We were in the same hall, Commonwealth Hall, and I never saw him in the choir.
So everybody that believes in singing must be a member of the choir. Honorable Tampuli, you have the floor.
Thank you, Mr. Chairman. My Lord, you are welcome and congratulations. See that you are a V-mate. I would have asked you to hold something, but it's all right. We'll do it another day. My Lord, I'm taking a cue from the question that was asked of you about empaneling by the Honorable Bitsidin. Now, there are a long line of cases which deals with especially the rule that a person shall not be a judge in his own courts. And from the cases of Attorney General versus Salah, Kwashi Aidan versus Akufo-Addo, Bosin and Apalu, and so on and so forth, all the way to the recent cases. You see that the issue GBA versus Ackaah and so on and so forth, and Urban. Now, those cases have arisen because the Chief Justice, maybe his powers or decisions are being contested, and he is supposed to be the person empaneling the courts. Now, your proposal that we should digitalize the platform is a very, very innovative one. Where do you think the Chief Justice would be in such matters like this? My Lord, the Chief Justice, the acting Chief Justice sitting right behind you. I'm not too sure if you are depriving him of something by digitalizing the empaneling platform.
Thank you, Mr. Chair. As I indicated, it's an administrative function of the Chief Justice. But we also live in a society where perception counts. Because anybody, even lawyers, will ask that why is he the person at the end of it and the one appointing judges? So that is why I think of such a proposal. The CJ, him or herself, will be maybe a panel head. But in a situation like that, his or her panel cannot hear the matter, and the matter could be assigned to the other panels which are established. So I think it's something that we ought to look at, because if people perceive that using your powers to administrative and panel leads to a favoritism, sometimes sidelining some judges who ought to sit and are not sitting, and others are being overburdened, I see this as one way of solving that problem. Thank you.
Thank you, Mr. Chairman. A quick follow-up. So under what circumstances would you recommend that the Supreme Court, for instance, departs from its earlier rulings in respect of that subject matter, that if a statute says that the person should sit, the person should sit, the doctrine of necessity and all of that? Is there any other circumstances that you see that the Supreme Court can depart from that? Thank you.
Sorry, is this in line with empaneling?
That's correct.
Yes.
That is so.
I think that we live in a society now where many of my colleagues are doing further education. People have specialized knowledge. I have on my own sponsored myself to World Intellectual Property programs yearly, and insolvency programs. So if you have a judge who has a particular expertise in an area, and there's a subject matter that law judge's expertise will help, that will be one of the exceptions, because then we'll help develop our jurisprudence. Thank you.
Chairman, I thank you. Congratulations. V-mate. Sharp.
After sharp, what is it that you cannot add? Honorable Omar, you have the floor.
Thank you, Chairman. My Lord, congratulations. My question is a reference to the constitutional review. At least we've had the Constitution since 1992. If you were to submit a question or a suggestion, what will you do? What will be the suggestion to the Constitutional Review Board?
Thank you, Chair. I think the first thing I seem to have mentioned it when I was asked the question. I will seriously recommend that we should have an independent judicial commission for purposes of appointment. And as it exists in Kenya and other places, so that people who are qualified, be they sitting judges or those in private practice, can apply. They assess your work. Once they filter it through and they think that you are qualified, it then goes to government, which will not have any control over the candidates presented. So that would be one thing I will recommend. The second recommendation, again, would be, I will also suggest that we do receive complaints against Superior Court judges. My recommendation would be that the reform should include the fact that if a petition is filed against a Superior Court judge to the President and is given to the Chief Justice, the Chief Justice should give that petition to the three most senior justices of the Supreme Court. The Chief Justice should not make the prima facie determination. The three most senior judges of the Supreme Court should be permitted to assess that petition, and their decision, if the need for committee, will be set. Otherwise, is dismissed. These are the two things I may think. And also, we may want to have a police independent commission to assess complaints about police officers. The police should not have the opportunity to, that is law enforcement, should not have the opportunity to sit on complaints against police officers. This will be some of the recommendations I will make. Thank you.
Thank you so much. I don't have a follow-up. My second question would be on what areas will you suggest as a judicial reform to ensure efficiency and reduce delays?
Mr. Chair, thank you. I think it might not be much of a reform, but building capacity of judges should be something that we think about. We are asking questions about incompetence and so on and so forth. I think judges' capacity should be built. And that means that we should be able to provide financial support timeously to the judiciary. I work as a partner of the JTI. The director has many programs, but there's no money to train judges. So I think that must be done. Just imagine you being paid in June 2025, the last quarter payment of fuel for you in 2024. So I think that the financial support ought to be given. We're talking about helping to avoid delays. We need to take a look at our rules. Some of the civil rules must be looked at. Recently, there was a provision in regards to juries. Let me say this. The jury system is a good system. The whole idea is that your peers have listened to your case and they have ruled on it. Can we have a statute where every Ghanaian of 21 years' name can be on the list of jurors at district assemblies, so that private individuals, everybody can be a member of a jury, rather than public servants who are the only ones who are chosen? And when the pool is basically enlarged, you have many people who will be willing to serve as jurors. And it's one way of enriching it, and let us have criminal matters day-to-day trial dates, so that when we start a trial, it should not be dealing with a criminal matter with a jury from 2022 in 2025. Let's have a system where criminal matters we start and we can complete timeously. Thank you.
Thank you so much. I think I like the jury system because I've ever served on the jury in the U.S. Jersey City. My last question has to do with this fear of tribunals. The NDC government wants to reactivate the tribunal, the government of the day. It's in the Constitution, but it looks as if it's not being used. One, it's here. It's 142. 142. Constitution is here. And I want to find out if it is legal, why do they have this fear? Thank you.
Mr. Chair, the honorable member asking me to assess why people have fear. Fortunately, I will not be able to find out why people have fear. The reality is that it's part of the law. It has not been used for some time now. It is being set up to deal with, we cannot shy away from the fact that we have delays in our system. Is it being brought to help clear this delay? Is it being brought to be given specific jurisdiction to deal with certain matters? I think it depends on what is the policy rationale in wanting to bring this. If that policy rationale is anchored in law, I do not think that anybody would be opposed to it. Thank you very much.
Thank you, my Lord. I think it's coming to address the backlog and the delays. Thank you so much, and I wish you well. Congratulations.
Honorable Patriotism Senior, you have the floor.
Chairman, just to congratulate you, I don't have any question for you. I don't have any question for you. Congratulations. Thank you.
Thank you. Thank you very much.
Thank you. I'll proceed to give the floor to Honorable Haji Aladi Ayamba. You have the floor.
Thank you, Chairman. Congratulations, my Lord. I have just two questions. One of them is about the retirement age of judges of the Court of Appeal and then the Supreme Court, which currently stands at 70. I have heard from certain quarters that we are thinking of 75. What is your opinion about it? And if you've heard it, that's if you are aware.
Thank you, Mr. Chair. I think I became aware through question of my other colleagues here. The reality is this. I think I do not have any statistics, but indications are that people retire at 70 and within a short time, they join the other side. The work of a judge is a stressful one. You burn the midnight oil, you sit up and write judgments. So I think that 70 is good enough. And let me say, even in other jurisdictions where they have 75, when you are about hitting 70, you can choose to be a supernumerary, which means that you've cut down your work, you choose what to do, and you'll rather give it to those who are young. So as my brother who once said here, I think the 70 is good enough. Let's stick to it. So that when we retire, we can have time to spend with family. Thank you.
Chairman, my second question is about our districts with courts and the lack of judges. I think this is about my third time of asking this same question. What is your suggestion on how we will be able to get judges to, I should say, the 216 or is it 17 districts as at now, so that we don't continue to delay cases, denying justice to people?
Thank you, Mr. Chair. I think the occupation of a judge work must be attractive. There are many lawyers who may desire to be judges, but if you join the bench and after 6 months you've not been paid because your name has not gone on the system, within that 6 months of your service, how are you supposed to support yourself? So let's make the job attractive. As we speak, my beloved Bogoso has a court. yet to be inaugurated, and I'm sure the people they are yearning to have a judge. But if people are not willing to join the bench because the package is not attractive, speak with those on the lower benches. Their situation is not the best. So let's make the job attractive, and I think we'll be able to have the best of the brains to join the bench for the benefit of our nation. Thank you.
Thank you, Mr. Chairman. I wish you all the best.
Honorable Jerry Ahmed, you have the floor.
Thank you, Chair. My Lord, congratulations to you. And you're welcome. My Lord, I've just perused Article 1461. And it talks about justice of the Supreme Court or a chairman of the regional tribunal shall not be removed from office except for stated misbehavior. I'm not going to talk about or incompetence. I want, in your view, to tell me what would constitute stated misbehavior. If you have about 5 of those or less, it's fine.
Thank you, Mr. Chair. I think this is not defined clearly, but I think what is a misconduct, all of us, when we see one, we should see it. There is a Canadian case called Mary Libel. What was deemed to be a misconduct was a judge sitting who became so frustrated with people who are in her court, and she made statement that they are lazy, they don't want to work, all they have to do is to engage in criminality. That statement was deemed a misconduct, and she was removed from the bench. Okay? I've been a member of an investigative body where a judge in the Upper East was sitting and didn't have a copy of the minerals and mining law. A lawyer agreed that, my lord, when I get to Accra, I'll get you one. When the lawyer got the law, the mistake the lawyer made was, instead of taking it to the registrar, he gave it to the client, and the client was going to give it to the judge. Somebody saw the person entering the judge's home, and a committee was set to investigate this as a misconduct. Of course, the committee eventually exonerated him, because we know that the litigant should not come to your home. So I think that many of the things that judges are required to do based on the ethics, if you go contrary to it, clearly may constitute a misconduct, depending on the facts to be determined.
Thank you very much, my Lord. So my understanding is that stated misbehavior depends, or misconduct depends on the facts to be determined. But these facts, as we have not seen the definition of stated misbehavior, in your view, what should we do about it? Should we define what stated misbehavior is?
I think at this stage, at this moment, Article 146 has become a topical issue. Maybe it's high time we have a CR or regulations, so some of these things can be properly defined, and everybody will know the parameters of what these are. Thank you.
My Lord, this also brings to mind, I know you are the kind of person who is very technologically inclined. I mean, I remember the last time I was before you was when you were in the High Court, and you had your own computers and things before you. So I labeled you as a gadget master. I want to find out, with the advancement of technology, the president is not in town, he's not in Ghana. The vice president is not in Ghana. The right honorable speaker is not in Ghana. At what stage would technology be beneficial to all the three that are not in Ghana? What would be your recommendation? Who is the president? Or who can be termed as the president?
I think, if I understand your question, if the president, for example, is in Geneva attending a UN program, and the vice president in Oslo, can we clearly say that out of the jurisdiction based on technology now, the person is absent? I am of the view that if matters can be regulated from there, depending on the situation, because clearly the absence within the jurisdiction may not be the basis to say that the person is absent. I think we are looking at a situation where even judges, we should have a situation where a panel, one may be somewhere, if they can be linked up virtual to hear a matter, should be possible. So that's how I look at it. We can all take advantage of technology to answer some of these nuances. Thank you.
So, would that be part of the recommendations you would pass on with reference to your issues on constitutional review?
Yes, I think some of these parameters must be clearly defined, and once they are distilled out plainly for everyone to understand that in such situations, the president or the vice president ought not to be deemed to have been absent and can still carry on his or her job, that will be very much welcome, so far as it has some statutory backing. Thank you.
Very excellent. My Lord, I just want to find out, how can the Supreme Court ensure some balancing with reference to, or in respect of, freedom of expression with the need to combat cybercrime and online misinformation?
I think in an earlier question, I quoted Lord Denning in British Steel Corporation. You know, I think free speech is not cheap. People should have the right to express themselves. But in expressing yourself, it should not be an avenue to abuse people and to defame people. We should recognize that online abuse is more serious than the old traditional way, because whatever you write here could be read in Australia or my made-up town of Ackaah-Boafo. They will read it there, and it may be online, it will never go. So I think that whilst we want to allow people to have free speech, there must be responsibility attached to it. And so I believe in free speech, but free speech must be with some responsibility. Thank you.
Does that mean that people should be extremely careful as to what they say and when they say and where they say them?
I would say that social media has not done away with our old tort libel laws. They are still applicable. So that if you choose to go contrary to the law on social media, as I said, in Pakenham versus North Carolina, social media was deemed to be like you sitting at a public park and you uttering something. If that will be taken as serious, if you do it on social media, it should be taken as serious. Libel laws are so applicable. Let's be very careful about what we put on social media. If you go contrary, somebody ought to sue you. The court will hear that. Thank you.
This will be my final question. Would you recommend that the Chief Justice's functions of being a judge and an administrator should be decoupled? Should we have just the Chief Justice doing the functions of a judge, and should we have an administrator doing the functions of just administrator?
Thank you, Chair. Insofar as the Chief Justice is seen to be the head of the judiciary, I think that decoupling may not be necessary. I think it happens virtually everywhere. It ought to be a balance on the part of the particular Chief Justice as to how much work he or she wants to engage in the courtroom and how much work he or she wants to engage in administratively. So I won't call for a decoupling of that. Thank you.
I was looking for that. Thank you very much, and I wish you very well. No further question.
It's now the turn of Honorable Roxanne Nelson. Kwame Dafamogbo.
My Lord Ackaah-Boafo, you're welcome. JS is soon to be. I'm very proud of you. I lost a case before you.
Is that your question?
I appealed, but I know I won't succeed because your judgment was sound. I tried the matter on a very thin line, but you distilled the law, and your writing style as a judge, it's unique. My question will come. You are in the mood of Justice Francois and Taylor and Co. and I urge you to keep it up. You write extremely well. Now, the question has been posed to your other colleagues regarding the non-definition of misconduct being a basis upon which a judge can be removed from office. But I differ. So here is my scenario. You judges have a code of conduct for judges and magistrates. And Rule 2 of that code says that a judge must avoid impropriety and appearance of impropriety in all of the judge's activities. That's contained in page 3 of the Code of Conduct. Is it not the case that where this is breached, this will amount to a misconduct? You are a lettered man. You're a man of letters. A code of conduct, if it is breached, if any of the rules in the code is breached, it will amount to a misconduct. You agree with me?
Thank you very much, Chair, and I'm humbled by your initial comments. Let me say this. Yes, it might amount to misconduct, but should that misconduct, depending on the facts, be the basis for removal? In other jurisdictions, judges may receive a reprimand. Some may receive you writing an apology. Some may receive counseling. So I think that, yes, depending on the facts, the misconduct will be established. But would that amount to a misconduct that leads to a removal? It's another matter. Thank you.
Mala, you took the wind out of my sail, because my second question would have been, that's why I said, if any portion of the code is breached. Now, to breach a code, it means that will have to be established based on the facts and the evidence. So when it is established that the code has been breached, then the second stage will be, what are the penal sanctions applicable to the breach of that particular code? So once we have a code of conduct for judges, every other matter regarding the removal of a judge will have to be based on that code of conduct. And so we'll leave this matter. Now, my issue is this. I'm waging an advocacy here, and it's in respect of career magistrates. Career magistrates don't receive equal pay for the work that they do with their professional career magistrates. Would you join me to ensure that they receive equal pay for equal work? And by way of providing further and better particulars, professional magistrates, they are entitled to official accommodation, official vehicle, official everything. The career magistrates doing equal work are not entitled to official accommodation, they are not entitled to official anything, save for the nominal salary. And I believe that amounts to great injustice being done to them, especially when they don't have the opportunity to progress. I think 3 of your colleagues who have been here progressed from the magistracy all the way going to the Supreme Court.
Mr. Chair, well, I think I will join you insofar as they do the same job, but ultimately, you are here, you are the one who makes the laws. I'm not sure any career magistrate mount a court without a statutory backing. If you, who is waging this advocacy, is of that view, then I will respectfully ask that you ask your colleagues to join you so that you have a law that will support the position. But on the periphery, I agree that if people are doing the same work, then they should have some benefits. Because in other countries, Uganda and other places, they still use some of these magistrates, and they have a better way of treating them. Thank you.
My Lord, your answer gives me opportunity to come back. We have enacted the law. That's the labor law, the Labor Act. Labor Act is very simple, that you must pay a worker for the work that he's done. You don't discriminate. So equal work, equal pay for equal work. Now, I've run into problems because I'm rather told that it's a policy of the Judicial Service. And I've raised the breach of the Labor Act many times at the committee level. So, while you've given me an indication, I may have to push this further. And actually insist at the committee level that policy must align with the terms of the law. So I thank you for your opinion. And let me wish you well. We'll have the opportunity to come before you. I wish you all the best. Thank you.
Thank you very much.
I'll then proceed to give the floor to Honorable Practitioner Appiah-Jay, Deputy
Right,
Minority
thank you very
Leader.
much, Honorable Chair. Honorable Nominee, I've had a critical look at your CV, and it has actually exposed me to a number of things that I have ever overlooked. When you were given us a brief about who you are, I noticed that I've always held the view that there's only one St. Augustine's school, and that's St. Augustine's Cape Coast, the college for which my brother and my leader attended. But it's good that you have exposed me that there's another one hiding here. Because when I was going through your CV, I was like, who in this world would leave St. Augustine's and go to Winneba Secondary School? That was my first impression about you. So I now get the difference between that. But my first question, since we are being watched and we have other people looking and following us, I wanted to find out why you did not complete your licensure course. Maybe it will inform people out there, where people who want to undertake such courses. Maybe if you can give us a little detail about why you abandoned it. Thank you.
Thank you, Mr. Chair. Madam Member, I think I did because I found out that I'm more of an advocate than academic at the time. And I found out that the courtroom was rather my calling rather than the classroom. So when the opportunity came that I migrate to Canada, I think I chose to migrate to be a practitioner rather than academic. Thank you.
Another observation I made on page 4 of your CV was about your national service history. You happen to have 2 different engagement, or I should say employment, within the national service. Your first one was at Wassa JSS, Wassa District for national service, and the second one was Aboafo PDC office. What were you doing there? Thank you. PDC office. Yeah.
Thank you, Madam Member. As you can see, there are 2 years. Unfortunately, I'm not so brilliant in maths. So my O-level maths was aggregate 7. And I couldn't, so I had to redo it. What it meant was I had to do 2 years post-A-level national service before going to university. So that's why you see 2 places there before my university.
What is PDC?
Well, at the time, I was from the Wassa West District in Tarkwa. So I think these were organizations during the revolutionary days. They called them public defense committees. So national service persons like me and some from the university were placed there. They were taking complaints of people, and we became their clerks, writing notes for them. Thank you.
Right. Thank you very much, Honorable Chair. I know that we as individuals, we have our own affiliations, we have our religious ties, and sometimes we have our own extracurricular activities. And as we speak now, I know that you may be holding membership in some political organizations, religious, and some other businesses. May I know what could compromise your impartiality when it comes to giving judgment in a particular situation where your association, as I have already indicated, matters? Thank you.
Thank you very much. Let me put it on record that I am not affiliated to any political organization. I'm not affiliated to any business as of now, apart from me being a member of the Full Gospel Businessmen Fellowship International. But I think impartiality and conflict of interest come in handy if a judge takes the position that his or her views will be challenged in terms of what is placed before you. Let me put it on record that I actually had opportunity to write an opinion against my own brother's law firm. I proposed to the panel that I wanted to recuse because I know my brother. They said, well, but it's not his personal case. And I happened to write a judgment and he lost. So I think it comes down to one personal integrity as to whether or not you think you are conflicted. And if you strongly believe so, you must quickly and immediately recuse yourself. Thank you.
Thank you very much. I listened to your answer on the reintroduction of the public tribunals. And I was wondering, why are we not looking at ADR, which is Alternative Dispute Resolutions, and we are only looking at the public tribunals? Would you please explain clearly why the difference between the two? Thank you.
Thank you very much, Mr. Chair. I think ADR is already part of our justice system. In many courts, you have ADR offices, and they deal with civil matters the more. If I understand it, the whole idea of public tribunals, their jurisdiction was more of criminal matters, so that the two are not the same. ADR, by the virtue of the fact that we have the ADR Act, and many Ghanaians are using it, which is one of the best ways to help decongest the courts. And in ADR, the parties must agree. If you are being prosecuted by the state, I'm not sure you can say that states, please, let's go to ADR, unless after you've been charged, you take the position that you want to engage in a plea bargaining. So I think that is where the difference is. Thank you.
Thank you very much. Honorable Chair, I have one other interest. Would you agree with me that public trust in the judiciary is declining, partly due to perceived politicization and corruption? How do you intend to contribute to restoring confidence in the judiciary, if approved?
Thank you, Mr. Chair. I think the judiciary, as I said initially, ought to be the integrity of the land, ought to be the arbiter of the land. So that if the judiciary is perceived to be corrupt, it is bad. But Madam Member, I want to say this. We seem to create the impression that the moment people get into the judiciary or some institution, they then become corrupt. I think there are serious philosophical questions for all of us as Ghanaians to ask. Because we must be corrupt before we join these institutions. So I think we should have that deep introspection as a people to understand, are we really corrupt? If we are, then we need to address it rather than placing it in sectors and in institutions like the judiciary. I've heard many of my senior colleagues say there's the judiciary and the judicial service. That is a fact. So any perception of corruption is bad. But I think the time has come for Ghanaians to have that deep introspection, that people don't become corrupt because they've joined the judiciary or they've joined the police. We must all find out, are we men and women of integrity? Thank you.
And my last question. May I know from you, what is your legal and moral perspective on child marriage and witchcraft accusation as it stands now? Thank you.
Thank you very much. I think that the girl child should have the opportunity to be educated. The girl child should have the opportunity to develop her talent, so that placing any child into a marriage against their wishes at a younger age is certainly no. But why are we in a globalized society 2025 still talking about witchcraft? I think that these are nuances that as a people we may have to address. We accuse people of being witches, and you find out what is the standard for making such determinations. So yes, I do not believe that children should be put in marriages at tender age. Every child should have the opportunity to develop her talent. And if there is a need for us to regulate that through law, I am all for it. But I think in many of these things, it comes through education rather than just imposing law. Thank you very much.
My follow-up on that. You do agree with me that no matter how you look at it, it's something that is still with us. And education and legal education itself has not even helped. We're getting rid of such perceptions and ideas. Don't you still think that regulation will help to address this need? Thank you.
Thank you very much. I think my initial question was not doing away with regulations at all. I think that we can have laws because, as you indicated, there are some people, no matter how much you educate them, their mindset will not change. So that if we ought to use the law as a whip to draw them in line, that is perfect. Thank you very much.
Thank you, Mr. Chair.
Thank you very much. I'll give the floor to the Vice Chairman, Honorable George Kwaku.
Thank you very much, Mr. Chairman. Justice Kwekutewia Ackaah-Boafo. Mbona Juma. Na uti nkwaso. Looking at your CV, in fact, I realize that you have quite a number of publications. You actually have publications, articles, and some presentations that you have done on quite a number of subjects, but legally related. The one that jumped at me is your opinion or papers you have done on African continental free trade, quite extensively. Now, so that's where I'm going to ask you a question to get your opinion on. You delivered a paper actually on dispute settlement on the African continental free trade. And my question to you is that, do you think, which is basically the subject matter, that African dispute settlement mechanism that the African continental free trade have developed at the moment is a hope for a much further integration of Africa? Thank you.
Thank you very much. In that paper, I actually criticized the legal mechanism. I criticize it because the system has followed the traditional one of making state parties standing, giving state parties standing when it comes to dispute settlement. And if I understand the African Continental Free Trade Area Agreement, the thinking is to help individuals and SMEs to be the main players. And my thinking is that if they have not been given standing, then the challenge is if there is a dispute, they have to route it through their government in order to have this resolved. And I see that as a bit of a challenge. Having said that, we also know that the AfCFTA is anchored on the roots of the World Trade Organization. There is a case called the Bananas case, where banana producers from Honduras and the rest sued so that the nations can come together to help resolve that. For our purpose, though, I propose that the mechanism may not, as it is, give only state parties standing. That is why Ghana, where we have the headquarters, our judges must be trained on the concept of the African Continental Free Trade Area, because many of the disputes may start from us. And if we don't understand the agreement, I think we may use our 25 to impose an injunction and the entire market may collapse. So as it is, it might not be the best, but it's the beginning. My hope and my desire is that the main players in the area may be given standing when it comes to dispute settlement. Thank you.
Mr. Chairman, with your permission, a follow-up question. I think I do agree with you. The African Continental Free Trade only came in at 2018, ratification in Ghana quite recently. There are a lot of dispute cases to come involving the 54 African countries. They all ratify. And I don't think the legal preparation, at least in Ghana, is adequate enough to deal with the dispute that will eventually come. Now, do you think that we will have to still take our cases to the international arbitration, or should there be an African molded arbitration for cases on the continent? Thank you.
Thank you, Mr. Chair. I think if we are talking about the African Continental Free Trade Area, the mechanism they have the dispute settlement panels, and then they have the appeals panels. And the thinking is that if there should be a dispute, this should be the means by which the dispute should be resolved. But as I indicated, the agreement gives only state parties standing, so that if Uncle Kweku's company is the one in dispute with a company from Kenya, then it's the state of Ghana that must be fighting for you. So that is where I take the position that the dispute settlement mechanism under the African Continental Free Trade Area ought to be looked at, should give the SMEs and individuals standing when it comes to this dispute settlement. But as we know, in many agreements, the parties themselves may have their dispute settlement mechanism, and so far as that is in their agreement, they are open to use that to resolve their dispute. But let Ghanaian judges be trained on the African Continental Free Trade Area, because we have the headquarters and they will come to us. And we ought to understand the market and how it will operate. Thank you.
Lord, flowing from this, you, like, as you've already indicated, you've won against arresting individuals solely based on statements from co-accused persons. How then should the judiciary guard against arbitrary arrests that are used to settle personal scores or suppress rivals? How should the judiciary boldly confront this to guide our democracy and the rule of law?
Thank you, Mr. Chair. I think it depends on what stage we are at. If an investigator comes to court and he said, I've done this investigation, I arrest somebody and put a person before the court, I think at that stage it will be difficult for a court of law to say that at that preliminary stage there's no basis, let him go. The only way the judiciary can confront this is when presented with the compendium of evidence, assess it, and say that there wasn't no basis for this arrest and no basis for the prosecution. So, and I think we've done so far. We've done well so far when it comes to such things. If ultimately there's no evidence, there's no evidence. And the court makes a decision. Thank you.
Lord, now you are going to the policy court, where you will want to propose reforms. So let me ask you, it's a court of liberty. Nobody would be up to be checkmating unduly, except perhaps, of course, the matter comes up for review, or long after you've left, a new panel comes up with a new view, which is the case in our courts. But for the time being, you've described this laissez-faire attitude in policing as a threat to public trust, and I agree with you. What, therefore, in your view, should be the legal or institutional reforms necessary to ensure investigations are thorough, ethical, impartial, and conclude in good time?
Thank you very much, Mr. Chair. I think I would take a cue from my last answer. If until matters are filed in court, based on our rules, based on the laws in the country, I think the court will have very limited role to play until matters are filed. So that these guidelines ought to come from the Ministry of Attorney General and the prosecutorial services to guide this. But we know we also have matters of delay in our rules. In other jurisdictions, they apply so well, where no matter the charge, it could be stayed if the matter has been unduly delayed. So these are things that we can have conversation about. Should somebody stand trial for 5 years without calling any evidence? These are conversations that we can have, but I'm not sure at the investigative stage the court will have much to do until matters are filed. Thank you.
My Lord, the police prosecutor comes to your court, says that a big man, a businessman, has reported of stealing. The stealing was a check. That, of course, he signed a blank check. And the houseboy tore it from the checkbook, went to cash it from the bank. When this boy was arrested, we are told that he confessed as having tore the check leaflet from the book and indeed cashed it. The police is so clear that he has satisfied the essential ingredients of stealing. But emphasis is that the money was taken from a bank account. My Lord, in a situation where the bank account itself is not provided, the bank statement is not tendered, yet prosecution tells you that before an independent witness, the accused confessed the offense. In your view, in that circumstance, would all the ingredients of the offense in the circumstance would have been met?
Thank you, Mr. Chair. And on this confession statement, if we look at Section 120 of the Evidence Act, is the accused admitting that indeed I made a confession, or is the accused challenging the alleged confession? I think that is the first part to deal with. The next part, again, the judge will have to look at the ingredients. If the non-provision of the bank account or the check clearly does not meet the standard, the court will have to rule that the standard has not been met.
So, my Lord, in a situation where the caution statement was properly procured, so the independent witness, yes, it is true that it was properly procured, but the bank statement of the businessman, which bank statement would show the withdrawal with dates and all, and the name of his houseboy is absent. The entire bank statement is not before you. would you consider the confession statement as sufficient to say the gentleman is guilty, as prayed by the prosecution?
Mr. Chair, my counter question is, if indeed by section 120 the accused there's no problem about a confession, then the question, what did the accused confess to? Did the accused because the fact ought to be explained. The man says, I stole my boss's money. Is it a position that after that confession, the person understanding all the facts that led to him being arrested and providing this, in the face of that confession, the absence of the check and the bank statement should be thrown out? I think depending on the facts, if these are all the facts, I think the confession statement
but my lord, in Tagore, the Court of Appeal was very clear that no matter what the accused says, the requirement to lead evidence on all the essential ingredients of the offense must not be compromised, to the extent that the accused comes into the box to say, I'm not guilty. Do you have some disagreement?
Not at all. I mean, I am a consummate jurist on meeting all the ingredients. If the ingredients have not been provided by the prosecution will lose. So that if in this situation, the non-provision of the check and the statement, which will all establish the fact that this is how it was taken, are not there, clearly my decision will not be conviction. Thank you.
So, my lord, to conclude on it, and just to guide your juniors and all of us students of law and practitioners, situations where confession statement has been procured properly, no doubt on it, it's not in question, but in the box, the accused now says, I'm not guilty. You are saying on oath that going by Tagore, all essential ingredients must be proven, correct?
The law is that all essential ingredients of a charge must be established. If it's not there, and the person, I mean, when the person mount the box and say, I'm not guilty in the face of the confession, then that person will have something to say. But even in the absence of the person saying something, by pleading not guilty, he or she has thrown the gauntlet at the prosecution. Prove it. Okay? By the person saying, I'm not guilty, the person has basically challenged the prosecution to prove the ingredients. And if the prosecution has not been able to prove the ingredients, the decision will have to be made.
Very well. My lord, now, as part of reforms, you are going to a court that undertakes reforms that helps shape public opinion and all. Do you think that there should be a minimum evidential standards to be met before lawful arrests? Do you think?
There should be a minimum what?
A minimum evidentiary standards to be met by investigators before lawful arrest.
Mr. Chair, my view is that before the police arrest someone, they ought to have some evidence for arresting the individual. And that would tailor in with your use of minimum evidence. Because I do not think that anybody should be arrested when there is no evidence for arresting that individual.
Very well, my lord. My lord, you spoke about forensic and corroborative proof. Now, do you think that the court should be scrutinizing arrests and detention procedures that appear to violate the rights of accused persons, especially in the absence of what you call forensic or corroborative proof?
Mr. Chair, I think that statement answers the question. That is why I questioned why was this individual arrested in the first place and why was he convicted in that judgment. It was the duty of the court to really assess the evidence and make a determination whether or not the threshold was met. In my view, the threshold was not met. So the court will have to review such matters thoroughly, and where somebody is not guilty, you don't find the person guilty. Thank you.
My Lord, do you think that the courts you are going to should play a more proactive role in enforcing socio-economic rights, health, education, and Article 37?
Thank you, Mr. Chair. I think the court has had the occasion to deal with some aspects of the directive principle of state policy. As I understand it, the jurisprudence now is that if those provisions can be aligned with a provision in other part of the Constitution which is or are justiciable, then this, the Apex Court will have to help enforce those. But we also know that there are provisions that clearly taken into consideration the way they are couched, and the state of the nation may not become applicable. But those which are applicable or can be aligned with other provisions ought to be enforced. Thank you.
You've used cases that are justiciable. Your student would want to help them with the principle of justiciability as expressed by the courts. I mean, just a bit of it they want to understand.
Thank you, Mr. Chair. The case that's come to mind is the SIBA case. And the Supreme Court clearly spoke out clearly on what will make the directive principles or the provisions of directive principles of state policy become justiciable. So I invite any student to look out for that case and read it. Thank you.
Very well. Lord, we've had two election petitions. The 2012 election petition, and one of the contentions of the plaintiff applicants, which the majority of the court rejected, was to the effect that some unsigned document that the EC had relied upon should lead to annulment of those results. Of course, the majority of 5 said no, those are mere errors, etc. But the substance of it must be upheld in spite of the statutory provision that says that if it's not signed, it should be annulled. In this case, the Supreme Court gave effect to the law in spite of express statutory provision, the CI. What is your own view on situations like this, where there is an express provision guiding an act by a constitutional or statutory body upon which a litigant mounts an action?
Thank you, Mr. Chair. I think, again, as we've been fed by the Apex Court, these decisions come down to the approaches of interpretation. For those who believe in textual commitment, they will say that this is what the law says and will apply it. For those who look at the purpose, they now profoundly use purposive approach. They combine that to make the decision in order to arrive at doing justice. My view is that there must be textual commitment to statute and the Constitution, and if that will not result in injustice, then maybe you look out for another means of interpreting. Thank you.
Now, if you look at the decision of the court in the 2012 petition and that of the 2020 election petition, by the way, my Lord, you're familiar, by the way. You're very well. Do you think that there are any serious matters of legal opinion to be reconciled?
Mr. Chair, cases are determined based on their peculiar facts. 2012 petition was based on the facts which were presented. 2020 decision was based on facts presented. And therefore, and we all can learn from any decision which is given by the Supreme Court. Yes, so there are lessons to learn, but I'm not sure I can sit here and say that there are matters to be reconciled. Thank you.
Lord, with respect, you've been at the Court of Appeal for 7 years, you said.
No, please.
How many years, please?
2.5 years. High Court at 7.5 years.
So you've been at the Court of Appeal for 2.5 years. Very well. Now, have you had any judgment of yours being overturned by your superiors?
Mr. Chair, not to my knowledge. There have been a few ones that I've seen affirmed, but I haven't seen one overturned. Thank you.
Your stay at the Court of Appeal, have you had the occasion of dissenting in opinion?
No, I haven't written any dissenting opinion at the Court of Appeal yet, no.
My Lord, I want us to delve a bit into mob justice. These violate right to life, presumption of innocence, and due process. We've dealt with issue of arrest. This is also another arm completely unlawful. Of course, the Constitution protects life and provides for due process. How, in your view, does mob justice and lynching violate such constitutional rights under Article 13 and the presumption of innocence under Article 19? And what should be the judicial role in enforcing these constitutional safeguards?
Thank you, Mr. Chair. I believe in the fact that nobody can use mob justice demonstrations to resolve a legal matter. If somebody has done something wrong, the judicial process should be allowed to take its place. Using mob justice clearly is illegal, and people who engage in it must be dealt with by the law. Thank you.
My Lord, what will be your response to those who unfortunately believe that the persistent lynching is as a result of lack of public confidence in the justice system? How would you, with these in mind, address some of the weaknesses fueling this breakdown of trust? Should you get to the bench? Should you get to the Supreme Court?
Thank you, Mr. Chair. I've already indicated the fact that the issue of the judiciary, people not trusting the judiciary, it's as a result of general perception of all of us. But as Ghanaians, we need to believe and trust in our institutions. People who are judges or those who work in the justice delivery system are Ghanaians. So that the question is, you don't develop this mistrust because somebody has gone to be a judge. You either trust the person or you don't. So let us have that faith in the judicial system and rather allow the court system to work rather than taking the law into our own hands. When people do that, they should be punished. Thank you.
My Lord, I have my ECOWAS Parliament campaign manager here, Honorable Ahi. He's saying that Western North Alliance. But I want you to assure him that you are safe. You are not under siege. He came here to be your advocate. But I want you to assure him that you are safe. There's no cause for alarm. Assure him so that he gets relaxed.
As I indicated, I happen to be the first native of the
My Lord, that is already known.
They are proud. So I think
Chairman, thank you very much for this opportunity.
Honorable, I've not given you the floor yet.
Chairman, please. Thank you, Chairman.
I will give you the floor.
So,
limited to you congratulating.
Yes, I will do exactly that.
Yes, so you have the floor.
Chairman, we are so happy. We are so glad that the first time in the history of Western North, we are having a Supreme Court judge. And I think that on behalf of the people of Western North, particularly centuries, we say a big thank to His Excellency the President Mahama, for this honor done the good people of Century. And our prayers are with you. We hope that you will go there and then shine to bring glory to the people of Century, and for that matter, Western North. By extension, Western region. Thank you, Mr. Chairman, for that opportunity.
But people are of the thought that you should have been the first Supreme Court judge, but not for you refusing to go to law school.
Chairman, you want to allow me also to say one or two? Because he has some association with WASA, Western region. So,
Honorable Member, he has said it on.
He never mentioned WASA.
Everybody.
He never went. Chairman, he never mentioned WASA.
The minority leader, you have the floor.
Honorable Nominee, this was introduced to enable you have some breather, so we go on. So let's look at some cultural intolerance vis-a-vis the need to ensure justice in our country. In your view, how robust should a court respond when cultural intolerance or community complicity is cited as justification for mob injustice, for mob justice? And what precedent should be set in dealing with perpetrators of such lynching?
Mr. Chair, any mob action can never be reasonable, and in that is with that as the base, it can never be transparent, intelligible, or justifiable. You can't use any cultural basis to lynch someone. So whichever reason you give, or anyone will give, it's not something that is justifiable. Thank you.
My Lord, do you think that the judiciary has taken very robust preventive role to curb mob justice, particularly through your pronouncement, sentencing, or collaboration with other state institutions? Can you share some thoughts on that for us? With us, sorry.
Mr. Chair, I'm not sure I'm in a position now to cite a case or two in regards to how mob justice or people who have been involved in that have been treated. But the bottom line is this. As I've said previously, anyone who takes the law into his or her hands to commit any crime ought to be punished. And you don't just punish the person because of this. Look at the charge the person is charged and brought before you, and you deal with the person in accordance with law. Thank you.
My Lord, we've dealt with arrests. I now would want us to focus a bit on how influential people in society use the police to enforce civil debt obligations. A practice that is considered as a violation of due process and criminalization of private debt. This, in my view, goes to the heart of Article 14 and the role and limits of the police and the Police Service Act 1970, Act 350. And also creates a problem between civil and criminal liability. My Lord, what are your views on this growing trend of creditors using the police to arrest and detain private individuals over unpaid debts? And how does this action affect public trust?
Yeah, my Lord, before you come in, I believe this matter has been dealt with by the court, in which the court stated, if my memory serves me right, that the police cannot act like an octopus, stretching their tentacles to grab jurisdiction in a matter that they do not have jurisdiction. But my Lord, you may proceed to answer the question.
Mr. Chair, my response to that is that clearly will constitute misconduct. And it's part of the reason I propose that there should be an independent police commission, so that people who allow themselves to be used in such situations should be properly investigated and where need be punished. It is wrong. We know that you cannot use the police to do something that is civil. So that would be my response, Honorable Member.
My Lord, I'm quite curious. Why is it that when it comes to the police, right violations and misconduct, you are proposing an independent commission outside of the police? But when it comes to the judiciary, your proposal is a kind of a peer review mechanism where peers within, or you propose that some senior members of the Supreme Court, 3 of them, in the case of determining a prima facie against a Supreme Court judge, that should be, instead of the Chief Justice determining prima facie. In the case of your place, you think that you should handle your own thing, but the police, you don't think that the police themselves having their PIPs unit can better handle it?
Mr. Chair, I think the Honorable Member may have misconstrued the position I take. We know that when prima facie is established, there is a committee set, and that committee is not made up of only judges. It's made up of ordinary Ghanaians or Ghanaian citizens who sit on it. So I think that structure is already set up. In terms of the police, we don't have that, and that is why I make that proposal. Yes, thank you.
So, my Lord, it is your case that police officers or security personnel who act on private individuals or institutions to intimidate, arrest, or detain debtors without a court order should face some sanctions, correct?
That is correct.
What about lower courts who entertain such actions clothed as though they are criminal offenses? And my Lord, by the way, this is a very notorious practice at the lower courts. I'm not sure whether there is any report coming to the judiciary at the top level to that effect.
Mr. Chair, the judiciary has a complaints unit, and such complaints, when made, are well investigated. Sometimes committees are set up to investigate, and committees' reports are acted upon. Thank you.
My Lord, some of your colleagues have shared their views on Article 66. My Lord, upon your full reading of Article 66 as it is, do you think that there is any ambiguity there too for interpretation?
I think I've already indicated that I believe in textual commitment. This article, as it is, I do not see anything which is ambiguous. But having said that, I must be careful because I'm on record to have said there was no ambiguity to Article 94 in ex parte senator, and I was quashed. So on this, I do not see any ambiguity, but that's all I can say.
Oh yeah, my lord, the ex parte senator, the majority disagree with you, correct? My lord, at least to give credit to your industry, don't say you were quashed as though it was 5-0. At least, my lord, Eni Yabwa saw some strength in what you said. I think the main contention was the procedure, and my lord Atuguba rested a lot of his reasoning on procedure. So you didn't do badly. So anyway, but let's look at the general discourse in the public space. In the public space, some people are even arguing 2 consecutive terms. That if a president serves 1 term, loses election, and wins again, and comes, he can seek for re-election. Well, what's your view on that?
My view is on the text in the Constitution. 2 terms. There's no indication as to concurrent or consecutive. So that my thinking is, I've told you that Article 66, in my view, is plain and does not call for interpretation at this stage.
Very well.
Based on the facts you've given to me. Thank you.
My lord, are you a registered voter?
Yes, I am.
Where did you register?
Ayawaso, West Wogan.
My lord, you have followed the politics of your country. Would you suggest ways to improve the politics to make it very attractive for public-spirited Ghanaians to partake in?
Mr. Chair, my response to this question would be, can all of us be Ghanaian patriots rather than political bigots? If we want to be patriots, and we see our nation as a country that is worth serving, I think we can cut down the politics and this nation will be better off for it. Thank you.
My lord, if you say we cut down the politics and this nation would be better, I agree. But are you able to give some 3 specifics that can help enrich this whole process?
Thank you, Mr. Chair. First and foremost, I think you, the politicians, ought to know that in an election, there can only be a winner. And you are calling on the Ghanaians to make a decision on your agenda and your proposition. Can we all respect Ghanaians that we've come to you for your vote based on policies we present rather than things that we do to have people vote for us? I think the internal democracies of these parties ought to be geared towards that so that it will reflect in the general elections. And that is what I call being Ghanaian patriots first. Thank you.
My lord, what you've just said in parts can be attributed to civic education, where the populace also get the necessary education, which education will help enhance the whole process. Do you think that enough attention has been given to civic education? And if not, what proposals have you in mind?
I wonder if now schools still have civics. As when we were in school, we studied civics, making our nation first. But I think much of the education must come from you, the political parties, because it is what you give to your supporters that they demonstrate. So that if all of you will see that, let us feed them with the right information, and the information is building a nation, I think when the NCC and the rest come in, then that will become another buffer to educate Ghanaians. Thank you.
My Lord, you become aware of, because you talked about patriotism, let me ask, you become aware of the Ghanaian pledge, that pledge, I promise on my honor. Can you recite it?
Mr. Chair, I'm not sure I'm able to recite it.
Try which aspect, not the full, any.
Well,
what you can.
Yes, the nominee is honest to say that I will not be able to recite it. So why will you insist? I mean, an honest answer has been given. I wouldn't be able to do this, but do it. No.
Lord, I did not say that in spite of you saying you can't recite it in full, you should still recite it. In spite of what is telling us that you can't recite it in full, you should still recite it in full. That was not the mainstay. I only said, share with that those aspects that immediately comes to mind. Did you get what the point? That I only said the aspects that readily comes to mind. You've admitted that not in full. So which aspect readily comes to mind?
I promise on my honor to be faithful
and loyal to
Ghana, my motherland. Thank you.
I promise to hold in high esteem our heritage
won for us
through the blood and toil of our fathers.
Exactly.
I promise to hold in high esteem
won for us
toil of our fathers.
Yes.
And I promise, pledge myself in all things to be faithful
and loyal to Ghana,
to uphold and defend the good name of Ghana. So help me God. Because I am helping. If you don't, the man, look, stop. Chairman, put off your mind. This is, look, okay, if I'm struggling, can you do it? If I'm struggling, I have made an attempt. If he said he couldn't, and I said, oh, an aspect. You are now telling me that
that is why I am not making an attempt.
Then allow me, I would want to make an attempt.
Because I don't want to struggle.
Don't worry, I would want to boldly make an attempt. When I make a mistake, I be corrected. I'm not afraid to make a mistake. It's good to make a mistake to be corrected.
But let me say this, honorable member, I think that in as much as a pledge, it's a great thing for all of us to know. I'm not sure Ghanaian patriotism must be anchored in our ability to recite a pledge only. There are other things that all of us can do to demonstrate our patriotism to the country. Thank you.
Lord, with respect, that will be all for you.
Honourable members, our revered guest nominee, at long last, the vetting of the nominee has ended. I will give the floor to the Vice Chairman to do the acknowledgement of our guests. So, Vice Chairman, you have the floor.
Yeah. Thank you very much, Chairman. Indeed, at long last. I will proceed to acknowledge friends, colleagues, and family members who are here to support the nominee. And I will start with number one, His Lordship Justice Paul Bafo-Boni, who is the acting CJ, and His Lordship Justice Emmanuel Yoni Kulindi, and His Lordship Justice Henry Anthony Kofi. The next person is Mrs. Jocelyn Kukua Ackaah-Boafo, the spouse of the nominee. And the next is Reverend Dr. Joseph Kwesi, who is a pastor of the nominee, and Mr. David. The next is Reverend Dr. Kojo Ackaah-Markin, who is also a brother, and Mr. David Ofori Ackaah, another brother, and Benjamin Ackaah-Jesse Esquire, who is also a brother of the nominee. And then the next to be acknowledged is Mr. Amo Tobin, CEO of Tobinco Group of Companies in Accra, and Nana Ampesi Beni Mireku, whose AKA is Dr. Tony Obin, a champion of Wasa Daman Division and Wasa Fiase traditional area in the Western region. Next is Nana Adwoa Posa, who is a queen mother of, sorry. All right. Okay, I have a revised version of the list here, so I will continue from the name I haven't mentioned. Now, next is, I was on Nana Ampesi Beni Mireku, who is Dr. Tony Obin, a champion of Wasa Daman Division, Wasa Fiasi traditional area in the Western region. Nana Adwoa Posa, the Queen Mother of Wasa Ampon Sasun in the Western region. Mr. Dixon Atta Nkatia, a.k.a. Kenricks, is a family. Mr. Joseph Okan is a family director, Full Gospel. Mama Maud Ama Okan. Dr. Reginald Hammer, who is a family friend. And the next on the list is Mr. Joseph Sasu Buama, also director of Full Gospel in Accra. Mrs. Afua Mfuafo McCarthy, who is from Edmonton, Canada. And we have another Canadian family here, Mr. Johnny Mfuafo McCarthy, who's also from Edmonton, Canada. And Mr. Alex Apia, Mr. Joe Abbey, church member, Emmanuela Adwoa Amwa, Esquire, Accra, Caroline Mensanyakun, is a sister, and Lale Giaga, who is a Esquire, a former law schoolmate, a lawyer, and a chartered insurer. I have here again Nana Asin Mensa, who is a circuit court judge, I believe. And the honorable MPs who came to support my own brother and my chief, Honorable Samson Ayi, the Deputy Minister of Trade, and the MP for Bodi in the Western North. And then I have here another honorable brother, Ejay Mensah, MP for Wasa East, and my honorable brother from the good people of Kwesi. Honorable, I had a name on the paper, but I have just as, oh, Fifi, the notorious Fifi. And yeah, that's right, I have it here actually. Philip Fifi Buckman, who is MP for Kwesi-Mintin, also in the Western region. And if I have missed anyone, please forgive me. We acknowledge all of you and thank you very much for coming to support the nominee. I will revert back. Okay, so the generosity of the chairman says that you should be granted 2 minutes, just like we did for Honorable Samson Ayi. So please.
Yeah, thank you, Chairman. Probably less than 2 minutes. I wanted to add some more weight to what my minister, Honorable Ayi, talked about relating to thanking the president for doing this great honor to the good people of Western region and Western North. My Lord is a distinguished lawyer, a judge, and the good people of Western region will always be thankful to the president. We are aware of the late Modibo Kran from Usayim, who was also a Supreme Court judge, and today we have another great son also from the region. All the people of Western region and the gods and everyone in the region are so grateful, and we wish my Lord well. We have no doubt that you excel. May the good Lord guide you and protect you, extend your territory, and make sure that you shine and shine very well for the good people of Western region. Thank you.
Congratulatory message is too long. You now have 1 minute.
Thank you, Mr. Speaker. Chairman, I would also want to add my voice on behalf of the Western Bar. Our president is Emperor Constantine Kujeji.